Tonight, we are looking for your input on the topic of eligibility requirements that are outlined in the paid family and medical leave legislation, and is an opportunity for members of the public to identify areas that need clarification in the legislation. These questions and areas needing clarification will be used to inform the official rulemaking process, which will begin in the spring. Again, this informal listening session does not replace and is in addition to the formal regulatory process governed by the Maine Administrative Procedures Act. To provide you with the roadmap of tonight's listening session, I will begin by providing an overview of the legislation that pertain to eligibility and the types of leave that can be requested. After the presentation, we'll then open the meeting to hear from the public. Participants who wish to comment will be allowed up to 2 minutes. If you wish to offer comment, please use the Zoom raise hand function, and you'll be called upon by a staff member assisting with this event, and the 2-minute time clock will begin. And because we had the slight delay, which was about 7 minutes, we do plan to extend this listening session a little past 7. And finally, given time constraints tonight, we please ask to keep your comments only on the topic of eligibility, and any questions directed to the department regarding the substance of eligibility will come through the official rulemaking process in the spring. We encourage you to visit the department's webpage on paid family and medical leave, where you'll find up-to-date information such as a PowerPoint providing an overview of the PFML law, along with the timeline that outlines key implementation dates. You can find this by going to www.maine.gov/labor/PFML. And with that, we will begin tonight's event. And so just give us a few seconds to share the screen. Great. So this presentation will be a little bit longer than the one regarding contributions because, again, eligibility and the types of leave that can be taken kind of go hand in hand. So I'll begin with the first presentation, or the first slide. So regarding the requirements and eligibility, these are the things of note. So, for example, when it comes to taking reasonable notice, absent a sudden emergency or an event, the employee must give reasonable notice to the employer to take leave. The reasonable notice part, I know that some people might have questions about what that exactly means, but it's something that folks can certainly ask a question about or offer a comment. But there is a notice requirement obligation for the employer as well. And that's also outlined in the statute. But if an employer fails to provide notice about the Maine PFML program, and the employee's right to take it if necessary, the reasonable notice provision is waived. And when it comes to the scheduling of notice, it cannot cause an undue hardship on the employer. And again, that is something we have received questions about, and it's something we definitely will be looking further into. And when it comes to providing verification for the types of leave, that is also required. And then when it comes to the wage part or the earnings part, the individual must have earned at least 6 times the state average weekly wage over 4 quarters before accessing the benefit. And so we put just one example, hypothetically, if this program were live today, the current state average weekly wage is $1,103. And so if you multiply that by 6, that should get you to that number below. So for the reasons an individual can take leave, you can take it for family. So if families are expanding, or to care for someone with a serious health condition, that's potentially eligible. When it comes to medical leave, to care for another individual's needs. We also have a safe leave provision in there, and these are for individuals or employees who may be experiencing domestic violence, or for the employee to care for a family member that might be experiencing domestic violence. And finally, there is also the potential for individuals who might be preparing for a family member to take military deployment. You could take that potential leave. And the types of leave that can be requested. There is continuous leave. So these are for employees who could be taking leave for days or weeks at a time for various reasons. And we also have intermittent leave where the employee is still working for the employer, but they're adjusting their time in a way where they're taking it off in increments. And we provided one example of that. And finally, there is reduced leave, where again, the employee still could be working, but their normal schedule has been adjusted due to the reasons that they're taking leave for. So with that, that concludes, I believe, this portion of the presentation. And so now we are going to allow the public to offer comment. And again, individuals will have up to 2 minutes to offer public comment on the topic regarding this presentation. So with that, I will start.
That Jake Lachance has his hand up, so I'm going to add you in. Great. Go ahead, Jake.
Good to go, Reggie.
Yep.
I appreciate it. Mr. Monahan, Reggie, and all the other folks over at the DOL. I appreciate you having these listening sessions. My name is Jake Lachance. I'm a government relations specialist with the Maine State Chamber of Commerce, which represents over 5,000 large and small businesses across the state of Maine. Just run through here some of the questions and comments in regards to eligibility. First is making sure that an individual is a Maine worker and is subject to the program. And I mean that in the case of possibly being a hybrid worker, of someone being part-time in Maine, part-time in another state. Obviously, most kind of the snowbird population is retired, but some of those folks still work. Obviously would apply to them. And then any recent relocation to another state. They've paid into the program during the base period and still meets the eligibility test, but they move to another state. Also, we have questions about how benefits and eligibility will work for workers with multiple employers. I know that's kind of in the realm of eligibility, but the other sections didn't quite match up as well with it, so I wanted to bring that up here. If they're eligible for benefits, and if they only need leave from one employer, and how those benefits will be calculated if they do have multiple employers. Statute indicates that leave must be taken in increments of not less than 8 hours. Just being specific in terms of if the intent is that that would be a full shift or workday, and they need to clarification and rulemaking of how it'll be applied. Some examples would be if someone is a part-time worker and only works 4-hour shifts, are they eligible for benefits if they miss a full day of leave? And if someone works 10-hour shifts, would they still be eligible for benefits if they came to work for an hour and then request to leave for the rest of the shift? In terms of eligibility, we are not quite sure about how coverage for terminated employees would work, or if it's clear that you must be working to be eligible to take leave. In Massachusetts, it explicitly covers employees for 26 weeks post termination, and Colorado directs terminated employees to the state. So just some clarification with that. Currently, unpaid leave laws across the country don't allow leave for employees at the same time for the same household and the same sick person scenarios. So if we could get clarification on how this will work under mandated paid leave programming, so employers can know what to expect in scenarios of family members taking time off for the same person, as well as employers who employ more than one family member that may be affected by the same medical event. In Section 850A A14, it defines employer to mean, among other things, any person, sole proprietorship, partnership, corporation, association, or other business entity that employs employees at a location in the state. However, in 850A13, the definition of employee does not say that the employee has to be employed in this state. Again, already brought that up, but does it mean that an employee may live and work in another state and still be entitled to benefits under Maine's paid family medical leave law? Would like some clarification on 850A19, which defines a family member to include de facto parents, grandparents, grandchildren, and siblings. Just clarification of what de facto and the definition of that means in this situation. Under 850A19G, further defines family member to include an individual with whom the covered individual has a significant personal bond or is like a family relationship regardless of biological or legal relationship. Just want to make sure the DOL will be providing guidance on what that relationship means and a definition there. And if there's going to be any guardrails, we see this as being extraordinarily broad, and really an issue if an employer is going to be able to challenge that designation or require some type of documentation. You mentioned it in the intro, but just specifying what the specific requirements or the definition of reasonable notice is. Section 852A contains the definition of serious health condition, which is broader than the definition of serious health condition under Maine's family medical leave requirements. If that's going to be the case, what documentation is going to be required to support the need for leave due to a serious health condition? And if an employee meets the definition of serious health condition under the paid family medical leave law, but not under Maine's family and medical leave requirements, can the employee take 12 weeks of paid leave, and then take the 12 weeks of unpaid leave, if that's going to be able to happen concurrently? I know I'm probably a little bit over on my time, but I have 3 more short points, so I really appreciate the leniency here, Reggie.
Yeah.
Thank you. 850B5 provides that leave may be taken by an employee intermittently in increments not less than 8 hours. This is really interesting as well, as I previously mentioned, because a lot of employers even have 12-hour schedules and stuff like that. So we want to make sure that that is taken into consideration. 850B10 provides that an employer is not allowed to compel an employee to exhaust their sick, vacation, or personal time prior to or while taking leave under Maine's family paid medical leave. This means an employee could take 12 weeks of leave and then take whatever other leave is available to them. And in many situations, this could result in 6 months or more of paid time off, which is a pretty big chunk of time. And lastly, and again, I appreciate the time here, 850B11 provides that Maine's paid family and medical leave will run concurrently with Maine's family and medical requirements and the federal family medical leave. However, it does not go on to state if an employee is ineligible for leave under the federal in the same benefit year, if that employee can take leave under Maine's paid family and medical leave. And does that mean that an employee can exhaust their 12 weeks of leave under the federal act and then apply for 12 more weeks under Maine's? So some clarification there. Again, Reggie, I know I was a little bit long-winded there, so I do appreciate the generous time granted there.
Yeah.
Thank you.
Awesome. Thank you. Thank you, Jake.
And I see that Betsy has questions, so I'm going to add.
Reggie, can you hear me?
Yep, I can hear you.
Hi, it's Betsy
Hey.
Olton from HR Maine Consulting, and I'm representing the Maine Local Government Human Resources Association for municipalities and quasi-municipalities and some schools across the state of Maine. My question or comment under 850A13, employee. The questions that we still need answers surrounding are substitute teachers, per diem firefighters, on-call folks, seasonal lifeguards, those types of employees. Are they going to be considered eligible? And if so, if there's more than one or two or three people that need leave at the same time, and it creates an undue hardship for the employer, who decides which employee gets to take the leave? And then my other question or comment is, unlike the Maine Family Medical Leave Act and the Federal Family Medical Leave Act, it appears there's no waiting period. In other words, an employee can start utilizing this leave at their new employer at day one. And we're looking for you to consider providing some sort of a waiting period before that's instituted. Thank you.
Thank you.
And it's G Milton, the question, I'll add you in. All right. Free to go ahead. I'm not for the Zoom.
Oh,
I'll be going to
yeah.
the computer.
Okay. I can't hear you. I think, let me see. Gonna ask you to unmute if that's what might be happening.
Okay, thank you.
Oh, there we are. Okay.
Okay, so I thought y'all control that. Okay,
That's
my
okay.
my bad.
That's all right.
That's okay. Thank you.
Yeah.
Appreciate you, Mr. Mohan and y'all putting this program on. My name is Milton Bullock. I'm sorry, my name is Milton Bullock. I am the Christian Science Committee on Publication for the state of Maine. I am yearly elected to the office by the three largest churches in the state of Maine. We are interested in primarily that Christian Science practitioners are considered. Our understanding is, as of today, is that this will be determined by the Department of Labor. So my question is that following as an example, the state of Massachusetts has a similar law and similar regulations, and we would be interested in seeing that that is considered. And of course, we look forward to working with as we move forward in this process. And that's our interest in our question.
Great. Well, thank you so much.
Is Cynthia, and you might need to repeat that, Angie, I don't think they can hear.
Oh, Cynthia, I see you have a raised hand. So,
Putting her in.
oh, okay.
I can move them, I just don't think they can hear.
Oh, I got you. Okay.
Hi, are you able to hear me?
Yes.
Hi, my name is Cynthia, and I'm representing a large group of human resource and payroll professionals in public school systems across Maine. And we had some questions regarding eligibility for our school employees. The first being, what would the effective date be for those who are employed under a collective bargaining agreement? Would there be a delayed effective date, as was with EPL, when the bargaining agreements expire? Another question we have is whether or not employees would be eligible for paid leave over periods of time when school is not in session and employees are not employed. For example, teachers in the summer months of July and August. Would those payments begin in September? Would those begin in the months of July and August? And similarly, would school employee be eligible for paid leave in July or August if the serious medical condition started in June? They are not scheduled to work in July and August.
Thank you.
Thank you for your time.
Thank you.
Adding Nate into this.
Okay. Hi, Nate. You
Hi
can-
there.
Okay.
This is Nate Cloutier with Hospitality Maine. I'm the Director of Government Affairs. We represent over 1,300 restaurant and lodging establishments of all different sizes across the state. Thanks for hosting round 2 of this FMLA webinar series. On the topic of eligibility, I'm wondering if the department is going to look into what the anticipated uptake will be at 2, 6, or 12 months after the program launches, based on what has happened with other states, and kind of trying to see what the predictability will be with that. I was looking back at the Maine Paid Leave Coalition's cost analysis that was used in the 2022 FMLA report. It looks like they used a contribution rate of 0.86%, which is a little bit under what is going to be in the bill, I presume, or in the law rather. Moving on, what will the verification process be for any type of family leave? And how is the department going to go about establishing what a de facto relationship means? Kind of what along the same lines of what Jake was saying. It's my understanding that in order to be re-eligible for the program after having found to have been abusing it in some form, is that you're only out of the program for 1 year. And I'm wondering if the department thinks that's a sufficient amount of recourse. I believe the way that the law is written now, that H-2B and other type of visa workers would be eligible for this leave. I don't know if that was the intent and when the law was being written, but a lot of H-2Bs are only here for the summer and tourist seasons. So not for any long length of time that might be of use to the program. So essentially, are they going to pay into a program that they're not going to be able to use? Thinking about solo practitioners and their eligibility, they present a pretty significant adverse selection and overall program integrity issues. Just keeping in mind how the department's going to go about policing solo practitioners. And finally, actually, I'll save this next comment so it's not really in line with the topic, but
Okay.
with that, I am all set.
All right. Awesome. Thank you, Nate.
Thanks, Rudy.
Up is Destiny.
Hi, Dusty. Can you hear me?
Oh, hi there. Yes.
Yeah.
Can you hear me?
Yes.
All right. Great. Thanks. Hi there. I'm Dusty Holman Sprague. I'm representing not only the Maine Women's Lobby, but also the Maine Paid Leave Coalition. I do want to just briefly, since I'm following on the heels of my colleague, Mr. Cloutier, who mentioned our report, and mentioned the 86% that was listed in that actuarial study. Just a reminder for folks who may be listening that the 1% payroll contribution is a maximum. It's not a guarantee. And so we actually think that the numbers are pretty clear that it's likely to be less than 1%. And that 0.86 is what we determined through our study that it's what we were looking for. So, or what would make the program solvent. So just a reminder there on that part of the law. A couple of the things that we wanted to bring to the table tonight, three key themes. First, that the definition of family is broadly written into the law on purpose. This not only brings in queer families who are more likely to rely on chosen family, but also we know that 82% of American families have non-traditional, non-nuclear family structures. That's why states like New Jersey and Washington, who have had paid leave for years, rely on the same kind of definition that we have here in Maine. And in fact, the federal government, our nation's largest employer, has had a broad family definition that does not require blood or legal relationships for more than 50 years with no ill effects. So we hope that DOL will rely on existing and successful broad family definitions to make sure that we can serve as many family types as possible in this program. We also, the second key theme is around clarity and remedies for urgent leave that cannot be scheduled. We know that many types of leave, like serious accidents, injury, and other emergencies, can't be scheduled. We heard many stories last spring of families with babies in the NICU. In the event that that leave can't be scheduled or is denied, and the baby does not live long enough for parents to remedy that denial, that's time they will not get back. So we are hoping that you will be bearing in mind how long an administrator will have to respond to applications, how long before an anticipated start date a decision should be announced, and that there's a clear process and remedies for unscheduled leave. Finally, we want to address the undue hardship portion of this around scheduling. Here I'm sharing information from our partner, attorney Jeff Young from the Maine Employment Law Association, who is one of the members of the Paid Leave Coalition. But Attorney Young just wants to remind us that we have in Maine law, in the Maine Human Rights Act, definitions of hardship which ensure that an employer has to provide a reasonable accommodation when individuals are otherwise qualified, that the employer has the burden of showing the proof that that accommodation would constitute an undue hardship. And finally, undue hardship requires significant difficulty, financial or otherwise. So we know that we want this program to work for employees and employers, and we also know that there are many cases in Maine law already that define how undue hardship is defined. So we hope that you're looking to those other sources, and we're happy at the coalition to continue to be a resource for you. And thank you so much for the work that you've put into these listening sessions.
Thank you.
Hello there. Can you hear me?
Yes.
Wonderful. Eamon Dundon from the Portland Regional Chamber. Thank you again for hosting these sessions. And I don't have really that much to add to what Mr. Kluter and Mr. LaChance said. But just one question that actually came up from a member of ours in recent days. Will there be a process through which an employer who suspects an employee is not eligible can challenge that employee's eligibility? I don't imagine this coming up in too many instances, but we do feel it's important for there to be an avenue if an employer has information that would lead them to believe the employee is not eligible, that employee ends up getting approved by the administrator for leave. Will they have an opportunity to challenge that should that evidence exist? And I'll leave it there. Thank you very much.
Thank you.
The selectman has their hands up, but
All right. let me
not
see.
to be promoted to a panel.
Oh, see allowed to talk.
Oh, no.
There he is. Okay. All right. Can you hear us?
Yep. Can you hear me?
Yes.
Randy Place. I'm one of the selectmen from the town of Morrill. I spoke during the first session.
Mhm.
And again, I was wondering under the eligibility and under a lot of these different topics we're going to be covering, if there could be an applicability section. Again, I'm from a very small municipality. We have 3 part-time employees that work 20 hours a week. And I would like to see there'd be something for small municipalities to opt out or do something that's significantly prorated, because it's just even as a selectman, I get paid salary. I'm like $10,000 a year. The other 2 selectmen get paid $4,000 each a year. There should be some way so we can just opt out. We do have time off, paid time off for sickness in the town. We started it a couple of years ago, and the employees were quite happy with that. It's 2 weeks. It doesn't, but it's a long ways from 12 weeks. And I can just see this. I'm not so much worried about this probably in our town, because they're all hard workers. I mean, they range in age from 40 to 80 years old who are employees. But I think there's room for abuse if we don't really take a close look at how this whole thing is managed. But small municipalities have got to have some way to opt out or do something, because this is just, in my opinion, I don't need state leadership to try to run our town to tell us how we should apply time off for our sick people. We'll take care of them. So I think there should be something, like I said, under applicability in these sections to give us an avenue, and we're willing to prove it. However, we need to do that. Maybe some type of a write-up or whatever from our personnel manual of what's allowed or what we currently allow to maybe meet the requirement in some fashion. But it sounds like everyone I'm listening to, including last week, there's a lot of big companies. There's a lot of different people with a lot of employees that they're dealing with, and we're not like that at all. Our plow drivers, we plow our own snow. We work on our own trucks. We get paid by the hour when we do that, but that's only during the winter months. So we have 6 plow drivers that get paid $20 an hour when they plow. How do you apply things like that? I don't know. I'm not sure this eligibility thing has really been thought through, but maybe it has. I haven't seen it in the regulations being down that specific, but maybe you can address some of that. Thank you.
Thank you.
I'm not seeing any other hands up. But there are some things in Q&A.
Okay. So there are some. Okay, thank you for those who have chimed in either through the Q&A or X questions that way. So we will keep those logged in. But again, we do have a little under an hour left. So please feel free to raise your hand at any time if you want to offer public comment or ask any questions for the department to consider. Okay.
Reggie, Betsy Olton, one
Yep.
more time from HR Main Consulting. I just want to clarify thank you so much for these listening sessions. You also are taking questions directly to your office as well, or sort of scenarios that people are questioning on how this is going to work. You're also going to consider those during the rulemaking process as well, correct?
Yes, and again, I'm going to try to not answer as many questions, but yes, for this one, yeah, we are doing it through these listening sessions, and there will also be the formal rulemaking process. That is a separate process from this that will allow the public to weigh in on any draft rules that will come up by the time by the time spring comes around.
Great, thank you.
Mm-hmm. So again, anyone who has any questions or want to offer any additional public comment, please feel free to do so.
Reggie, in the interim while we're waiting, we can.
Oh, we got one. Yeah.
I was gonna say we can do the Q&A.
Okay. Yeah.
They can't see them.
Oh, right. Okay.
In the meantime, I will let Michelle in.
Hi, Michelle. Can you hear us? Or me?
Can you hear me?
Yes.
Thank you for taking the time to listen to our questions. I would just ask that we get some clarification. There was different language in some of the bills that were proposed in terms of maintaining employees' health insurance, that if they are no longer receiving a paycheck from the employer and now receiving benefits through this program, that in one case it was proposed that the employer would have to continue the health insurance as long as the employee paid their share of the health insurance premiums in advance of taking the leave. And so we do need some clarification whether or not that is a requirement. What would happen in the case that an employee fails to pay them? What kind of forgiveness period must we grant them when they're not being paid and no longer can have a payroll deduction? How long do we have to wait before their health insurance is then canceled?
Okay. Thank you.
No more hands at the moment.
Okay.
I
So.
want to go just read through the Q&A.
Yeah, so some of the questions that we've gotten, thank you for those who have added the Q&A. So we've gotten one question around, for example, how will coverage apply for schools who have sabbatical leave language in their collective bargaining agreements? Does an individual have to actively be working to qualify for paid leave? We've gotten some questions around eligibility and the substitute teachers and coaches in schools, which we've heard a little bit from others. Gotten some comments around PTO and using Massachusetts as an example to allow employees to use their PTO accruals to receive 100% of their typical weekly wage between the employer and the state. And then we got some other questions around if an employer offered a paid leave program, could they opt into the program or would they not qualify? So thank you for those, and those will be documented as well for us to consider. But also too, if folks want to raise their Zoom hand and offer any public comment, please feel free to do so now. Okay, if not, then I'll continue to read some of the questions. We did get another question around how's the state defining family? And is there a thought to requiring a person to work 12 months? And I'm assuming make it 1,250 hours. That also is in line with the Unpaid Federal Leave Act. And then also, again, we got more questions around the wage threshold for per diem workers. Seeing.
I'm not seeing
Yeah, we're not seeing any other hands. I know we were planning to go a little bit after 7 p.m. But if there are none, oh, we got Michelle. Okay, yeah, we got a couple.
So again, thank you for taking some additional comments as we examine the limited information we have about this leave plan. I think that we really need to have some very good guidance on exactly what will and won't be considered interference or discrimination against someone taking this leave if the employer is also at the same time trying to comply with, say, the federal FMLA requirements, that just because they may be eligible for this main paid leave, the employer still has to comply with the federal law. And so if the employer is then asking for additional medical information, that would not be to comply with the federal law, that they would not be considered interfering with somebody taking their main paid leave law. If they are asking for some sort of documentation of family status in order to comply with the federal law, or the military exigency in order to comply with the federal law, that would not be seen as interference or discrimination in terms of somebody taking their main paid family leave, but simply the employer being caught between many different laws and requirements that they're trying to comply with all at the same time.
Thank you. See, okay, we have Lynn. Yeah, Betsy.
It's Betsy again. Sorry,
Hey.
I'm a broken record. One
Okay.
comment, and I don't know what section it is. It's 10D, I think it's under 850A, where it talks about requiring a public employer that is a party to a collective bargaining agreement in existence on the effective date of this subchapter. If you could clarify what that date is, it will make a difference in terms of when the collective bargaining agreement expires and when those employees would be able to use that benefit. Thank you.
Okay, thank you. I think we have Lynn. You want me, I can, oh, there she is. Hi, Lynn, can you hear us?
Yes, can you hear me all right?
Yes.
I just want to make a quick comment as an employee, not an employer, and say thank you so much for your hard work on this, and for everyone who's written this legislation. As a young person who hopes to have a child someday, it means a lot to me and friends of mine, family of mine who feel as though FMLA is not enough, and folks who are working class and working regular middle class jobs full time just can't afford to have children. And I think this will keep a lot of younger people in Maine. So I just want to give some support to those who have spent a lot of hours working on this. And I look forward to reading into the finer details. And thank you for your time.
Thank you. And so we did get a couple of more things in the Q&A. We did get one question about, for clarification, if an employee worked in Maine, and then said move to New Hampshire later that year, will they still be eligible, for the program? We've received that question, before in the past. Are overtime wages considered, when determining eligibility? Oh, yeah, sorry, overtime. Yeah, okay. Then we did get a comment around asking us to consider allowing organizations under 10 employees the option to opt in to paid family medical leave. She understands that it will not be required, but allowing organizations the ability to provide this for their employees would be beneficial for many people who work smaller companies in the state. And again, we have just a little over 30 minutes left. So if people want to chime in, this is the opportunity to do so. But also too, for the sake of time, if there are no other questions, we could end before 7 or a little after 7 p.m. due to the delay. But just wanted to leave open this space as well for as long as possible. I'm gonna do one. Sounds like there's no other raised hand, so I did get an additional comment as well. So one question is, are stipends, buyouts, holiday checks part of compensation? So thank you for that question. It will also be documented. Also received another one. Will new moms be eligible for up to 12 weeks of leave for bonding with the baby born prior to May 1, 2026, when it's the start of the program, which is the start of the program, where benefits go live. Okay. So we're gonna do one last call for anyone who wishes to speak. And if not, we can conclude the night early. And seeing no other raised hands, we will, I guess, conclude this listening session. But before we sign off, there will be 2 additional listening sessions. The next one will be February 12th, and that will focus on private plans. And then the final one will be on February 28th. That will be an informal public comment period to comment on any provisions regarding the PFML law. And so again, we want to thank you for attending tonight's event. And if you want to visit our webpage on paid family medical leave, please feel free to do so by going to www.maine.gov/labor/PFML. And that's where you'll find up-to-date information, including the implementation dates. So again, thank you all for chiming in the Q&A and offering public comment verbally. And hope everyone has a great night.